Good morning, everyone. Thank you so much for joining us. I'm just going to wait a few more seconds and let the rest of the attendees who are joining us jump in, and then we'll get started. All right. Well, I want to get started as quickly as we can. So I just want to welcome you to today's webinar on ADA compliance. I'm Cindy Nellis. I am the director here at the Penn West Clarion Small Business Development Center, and we're glad that you are with us. We will be discussing the Americans with Disabilities Act, which is one of the many federally mandated laws that employers must comply. And administering the ADA is complex when you consider what you can and cannot ask during interviews, when dealing with reasonable accommodation requests, and so much more. Just a few logistics before we get started. We will be recording today's webinar, and we'll be sending you out that recording, as well as following up with the PowerPoints that you'll be seeing today. So with that, I will start to record. Oh, let me see. I think we already are recording. Let's see a second. Okay, says we are recording, so we're good. All right. Let's see here a second. All right. So just to get started, all participants have been muted, and your video has been disabled. If you have a question for me, your host, please enter it in the chat as well. If you have questions for our speaker, Pam Watkins, please enter that in the chat as well. We will be monitoring the questions throughout. However, we will be answering questions at the end of today's webinar. I'd like to get started with introducing you to the Small Business Development Center. The Small Business Development Center, we are a grant-funded program with a mission to help businesses start, grow, and succeed. And we do that through providing education, information, and tools to help businesses make better business decisions. The way that we provide our services is through one-on-one outreach consulting to those looking to start a business, as well as those who are in business. And please note that our services are provided at no cost, and it's confidential. The Small Business Development Center, we also provide training in the form of in-person seminars and workshops, as well as webinars. Most right now are being provided as webinars, which provides an easy way to get information out to the largest audience. We also have a lot of great industry and market research databases that you can have access to just by becoming a client of the SBDC. And in working with our clients, we have a lot of great business resources that we can help through many of the needs that you have in operating your business. So a little bit about the Pennsylvania Small Business Development Center network, because I know many of you are located throughout our state. There are 15 SBDCs in Pennsylvania, and we all cover specific counties. So this map will show you specifically what SBDC covers your county. And just to note how we're able to provide our services at no cost is through our funding partners, those who are invested in our program, which is our host institution. So mine is Penn West Clarion. The Small Business Administration funds us on a federal level, and the Partnership for Regional Economic Performance, which is a program through the Department of Community and Economic Development, funds us on a state level. The other thing I wanted to mention, our SBDC here at Penn West is also a WEDNET partner, and WEDNET stands for Workforce and Economic Development Network. That network was created to help companies stay competitive by updating and improving employee skills. So as a WEDNET partner, we are the organization that you would contact in applying for WEDNET dollars. So it's a grant that you can receive for training your employees. There's a number of different things that you need to be eligible. First, your company needs to be eligible, your employee that you're training needs to be eligible, and the training itself needs to be eligible. So we're here to help you find out if this training funding is available to you and help you access those funds. Okay, well, let's get to today. I'd like to introduce you to our speaker. Pam Watkins is an accomplished HR professional with over 30 years of experience in the public and private sectors. Pam has the in-depth knowledge of implementing human resource management strategies to recruit, train, and retain a high-performing and motivated workforce. Pam has been a change agent specializing in organizational development, talent management, organizational restructuring, employee relations, and health and safety. Locally, Pam has worked as an HR and safety director in several manufacturing companies and as site administrator managing CareerLink offices in Venango, Crawford, Clarion Forest, and Warren counties. She has experience with an international company managing HR, employee health, and safety functions for its employees in 38 states across the U.S. Pam's experience covers all aspects of human resources and safety, including company compliance, recruiting, onboarding, training and development, performance management, employee retention, benefits management, payroll management, compensation programs, and employee relations. Pam attended Penn State and the Human Resource Degree Completion Program at Geneva College, and she also holds a bachelor's degree in holistic health and spiritual care. And she's certified as a safety professional in the US and in Canada. And Pam, we're excited to have you. Thank you so much for being with us. And I'd like to turn it over to you now.
Okay, thank you. So after that long introduction, I can summarize my background by saying I'm an HR geek. And so I'm excited to be with you this morning to talk to you about ADA compliance. And what it actually means to organizations. So without further ado, we're just going to jump right into it. So most of you know that the Americans with Disabilities Act was designed and developed to ensure that we didn't discriminate against individuals that have disabilities. Today's agenda, we're going to cover employment practices, who's covered under the Act. We're going to talk about disabilities and substance abuse and how to make reasonable accommodations. What does a reasonable accommodation actually look like?
Hey, Pam, could you share your video?
Oh, I thought I was. Oh, I'm sorry. I thought I was.
That's okay. I had to take it over and then have you switch back to yours.
Okay, let me just see where I'm at. Hang on one second. Slideshow from begin. No, it's not. Share screen. From the beginning. Now do you see it, Cindy?
Yes, it looks great.
Okay, perfect. Sorry about that. I was getting ahead of what we're doing. So we're doing talking about what are covered employment practices under the Act, who are the covered individuals, disabilities and substance abuse. And then we're going to talk about what is a reasonable accommodation and how do you go about making one. So a little bit of history. The ADA came into Act in 1990. And I was practitioner back then in human resources. And I remember it was a mad scurry of people putting in handicap accessible bathrooms and handicapped ramps to gain entry into places of employment. And we didn't really think a whole lot, at least I didn't, beyond that at the time, other than we've got to make sure that we're in compliance with what was mostly at that point in time, physical requirements to get in and out of facilities. But the Act has always covered those individuals with disabilities. And remember, not all disabilities are visible. In 1990, it started, but then the Act was amended to include what is now known as the ADAAA. And I'll explain what that means in just a minute. But the ADA, if you're an employer that has more than 15 employees, you must comply with ADA requirements. Again, it's to protect individuals with disabilities from discrimination. And you've all heard the term reasonable accommodation. So people say to me, well, what's reasonable? And we're going to get into an explanation of that. It's enforced by the United States Equal Employment Opportunity Commission. And some states also have state laws that enforce this to a higher or more strict standard. When the act was amended to the ADAA, it includes people that are perceived by the employer to have a disability. So, if I come in to an interview and God forbid I'm pregnant at my age and I'm visibly pregnant, and you perceive that, you talk about that, oh, well, she's pregnant, she's not going to be able to work very long as an applicant, because she's going to go off on maternity leave. I'm covered. I'm obviously covered because of the pregnancy, but I'm also covered because you're perceiving me to have a disability. So under the Act, the conditions that qualify as disabilities may include epilepsy, mental illness, alcoholism, or all of the above. So just to yourself, answer that question as what would you select? Would you select A, B, C, or D? So the correct answer is D. All of the above are included under the ADA. So let's talk about why it's so important. So it's unlawful to discriminate. We all know what Title VII says, and we understand that we're not going to discriminate against, race, creed, religion, sex, sexual orientation, and all of those things. But disability is a big part of that. And in particular, it's unlawful to discriminate in your employment practices that start at recruitment. So keep in mind, ADA covers everybody, including your applicants. So you're not allowed to discriminate in recruitment, pay, hiring, firing, training, job assignments, promotion benefits, pretty much anything from this, what I'm going to call the life cycle of an employee, from the beginning where they apply for the job or where you put out an ad to recruit for the job to the very end when they leave your employment. So it's a wide scope. Covered individuals include applicants, like I just said, and employees. It also protects people from that are, for example, perhaps I'm an applicant and my spouse has a severe life disability, and it's well known. I'm not able to be discriminated against because of my husband's disability, my association with anyone that has a disability, for fear that I might have to be a caretaker. So let's expand on that. You're looking to hire somebody and you have an applicant come in, but during the interview, they disclose that they are also a caretaker to their loved one at home. You can't discriminate because they may have to take time off to take care of a loved one at home. So under the ADA, qualified individuals with disabilities are those that have a skill, education, and they meet your job requirements. So it's people that could perform your job duties with or without a reasonable accommodation. So if they can perform what is known as the essential functions of a job, then they qualify for that position. Now, I had a client call me a few weeks ago, and they said, hey, Pam, I have two candidates. One has a disability, one does not. They're both kind of equal. Do I have to hire the candidate that has the disability? The answer is no. You're always going to hire the most qualified candidate that matches your job description. So job descriptions become an essential part of the ADA, and we'll talk a little bit about that in a moment. I'm going to pop over here to the Q&A real quick. We're going to talk, Regina, we're going to talk about drug abuse and alcohol. Okay, we're going to answer all these at the end. I just wanted to, if there was something on this slide in particular. Okay. It's also against the law to retaliate against applicants or employees for asserting their rights under the ADA. So if an employee comes to you and asks for an accommodation, hypothetically, they want a new chair because they're having lumbar issues, they're having back problems, and they're requesting an accommodation to get a new chair for the workplace. You can't retaliate against them, you can't, go in and say, oh, they're just being a nuisance. They just want, a new chair and this is how they're getting it. It's unlawful to discriminate against them based on any social relationships that they may have with an individual that has a disability. So it's more than just a family relationship, it's business associates and other individuals as well. One of the things that I always get questions on is attendance and how attendance applies under the ADA. So a little humor, I've used up my sick days, I'm calling in dead. Well, under the Americans with Disabilities Act, sometimes time away from work may be necessary. And the act doesn't specifically say you must give somebody so many hours a week off for disabilities, but we're going to use good common sense. And we're also going to be meeting people where they are. If you have a good employee and they need some time off for regular medical monitoring or anything else, you're going to accommodate that just like you would for anybody going to a medical appointment. At the same token, if you have 50 or more employees and you have FMLA available, they may qualify for family medical leave. So it's one of those things where when people ask me about attendance, it depends. We want to do the right thing by our employees and be heart-centered employers. Because if you have a good employee in this day and age, you do not want to lose them. It's very, very, as you all know, challenging to recruit. So how is disability defined? You heard me mention earlier that not all disabilities are visible. But a disability under the Act has to fall into what is called as a major life activity. So major life activities they run the gamut from walking and sitting and standing and reading and breathing and eating to actually, caring for oneself, performing some manual tasks. It can be they have difficulty learning. Not all people learn the same way. So I encourage people that are bringing new hires into their workforce to ask them what helps you learn the best? How can we get you up to speed the quickest? Are you somebody that likes to read a manual? Are you a hands-on learner? Do you want a combination of the two? Do you want me to do it and then, let you do it on your own? So we have to start asking people how they learn. So an employer does not have to hire or retain someone just because of a disability. So frequently, this has happened more times than I care to actually share with you. I get a call from an employer and they say, Pam, we need you to help us terminate someone. And I say, why are we terminating? Well, it's poor performance. Okay, is it documented? Well, no. So what I talk to them about is, one, if I look in the personnel file, what's there? Are there performance appraisals or reviews that say that they're performing? Are there any written counseling notes? Are there any coaching notes? Are there any disciplinary notes? If the answer is no to all of that, or they have good reviews and nothing in the file that defines that they have poor performance, then I have a different conversation with them. But where it relates to disability is as I'm inquiring about all of these things, it comes out that this person, oh, by the way, was out on a medical leave for XYZ. And ever since they came back, they just don't seem right. They don't seem the same. They're not performing as well. So that falls under the ADA. So if you have a job performance issue, please by all means address it, but don't wait and don't tie it to a medical disability. The two are two separate things and should remain as such. You do have to accommodate under the ADA, but you don't have to accommodate poor performance or unacceptable behavior. So I do get asked about that a lot. So let's talk about the types of impairments. The list is extensively and exhaustive, what might qualify under the ADA, but it's physical or mental impairments. It can be a mental or emotional illness. It can be specific learning disabilities. Someone that is on the autistic scale may qualify under this category. It's not just people that have what I'm going to call visible illnesses, that are in a wheelchair or they're blind, they have hearing aids, whatever. So be aware that sometimes people have disabilities that you won't ever know about until there might be an incident. This is where I tell employers, please make sure your supervisors and managers, people that interact with your employees day in and day out, are trained, because it's not always that the employee has to come in and say, I have a disability, please accommodate me. 9 times out of 10, that does not happen. How we find out about these things is that the supervisor has a conversation with the employee and the employee says, gosh, my back hurts and I just can't do the lifting anymore. Well, then the supervisor says, well, okay, well, I'll move you. Okay, well, I'll move you to another area where you don't have to lift as often. Well, that's great and that's fine. But if lifting is an essential part of that employee's job and you temporarily move them, what if they need a long-term accommodation? What if there's something that could be put in place so that the employee could continue to do their job without hurting their back further? So a lot to think about, but I highly recommend not only a strong ADA policy and forms to accompany that policy, but I recommend that if you haven't already, please get some supervisory and management training done around this so they know what are the red flags or words that they hear that they go, oh, I better refer that to human resources or my designated person in my organization. So here we're going to answer one of the questions I saw in the chat. So disabilities and substance abuse. So one of the hottest things in the workplace right now, other than having trouble finding employee, is mental health and substance abuse. Alcohol is protected and qualifies as a disability. So a person that's currently using alcohol is not automatically denied protection because they're continuing to use alcohol. If they're in treatment, for sure they're protected. And if you have to do any kind of discipline with them, again, this is where if they're a functioning alcoholic and they're drinking, they still can't come to work under the influence. You have a right as an employer to make sure that they're doing their job well and being safe and keeping your other employees safe. But it does qualify in most of the time for a reasonable accommodation. Drugs. A drug addict is only protected if they are currently in recovery and not a current user. So let me say that again. If they are in recovery, no longer using drugs illegally and receiving treatment or are rehabilitated, they are protected. But if they're currently using illegal drugs, they are not protected. And I would encourage you then to follow your normal substance abuse policy and take whatever steps you need to. Sometimes you can, and I may be veering off topic a bit, but to put this out, you as an employer, if your drug and alcohol policy doesn't say this, you should consider putting it in. Sometimes it's helpful, just from experience, to refer someone to a SAP assessment. That's a substance abuse program assessment. And when in your policy, you can say whatever the assessment says, you're required to follow those guidelines. I've had success stories in doing this with employees. I had one of the most rewarding compliments that I've had in my career was somebody who is struggling with drugs and alcohol. And we sent him to an SAP assessment and he got into treatment. And he followed all the treatment. He went to his meetings, went to his counseling sessions, participated in group meetings, brought his documentation in as requested. And a year later, he came into my office and he said, "You totally changed my life for the better. Since I've been sober and I've been clean, I'm functioning. I have partial custody of my children. He got promoted at work, and I'm not going to tell you that it works in every case because I've had frankly more failures than successes. But if you haven't considered that, I urge you to do it. So under ADA, alcohol, yes. Illegal drugs, no. What do you do to make a reasonable accommodation? So a reasonable accommodation is any modification or adjustment to a job or the work environment that will enable the person, the qualified individual with the disability, to perform the job duties or participate in the application process. So the picture on the screen, this is actually something that I talk about in my diversity, equity, and inclusion training. But what I want you to see from this picture, you can see that equality on this left side is everybody's equal. Well, some people can reach the books and some people can't. In accommodation terms, if you look at the equity side, you can see that everybody can reach the bookshelf. They just need some different heights. They need different adjustments. And that's how I want you to think of accommodations. What can we do to make everybody successful? That's what it's really about. So people say to me, well, we hear about essential job functions. What are they? So under the ADA, essential functions are defined as the position exists to perform the functions. Few other employees can maybe perform the function, or it's a highly specialized function where somebody needs industry knowledge, or they need special education and training or certifications to perform it. What I'm going to do is break it down in layman's terms. When I think about essential job functions, and I'm writing a job description, I ask this question: this job exists to perform what? And then I take it the next level. This job exists to perform accounting functions. Okay. Then you're going to the next level is, where does this individual receive their information from? Okay. And workflows from someone to someone. What do they do with it? And where does it go when they're done with it? So I think of it as kind of information coming in, received, and then sending on. So when you think of those two questions, it becomes very easy to write your essential job functions. You also have to think about the physical job functions, job requirements. Are they going to be standing for extended periods of time? Are they required to sit for extended periods of time? And in writing those job descriptions, if you don't know what people are doing, you walk out and you say, hey, tell me about your job. What do you do? When I go out and meet with employer groups and I say, well, you've got on the job description that they've got to lift 75 pounds. How often do they do that? Well, I don't know. That's just the heaviest piece out there. Well, so I walk out and I say to the employee, how often are you lifting this 75 pounds? And you find out it might only be once a month. And easily 2 people could help with that assist and get it done. So be careful of your job descriptions, including things that you really can't validate or substantiate if you're ever challenged. So examples of essential job function accommodations might be providing a special phone for a hearing impaired receptionist. It might be giving people frequent stretch breaks if they have muscular disorders that require long periods of sitting and standing. Could be a modified work schedule. Might be somebody that learns by written job instructions instead of verbal. Maybe you have to communicate with them through the written word more. So here's what not to do. I was working with an employer, and they had temporary employees in their workplace. And so this temporary employee went to the supervisor and said, I can't do this job. I can't stand all day. So the supervisor moved the individual to a sitting job. She did that job for one day. She went to the supervisor and she said, I can't sit all day. So the supervisor then passed her off to another department. And it's kind of like, here, she can't work in my department. Here we go. That department required her to go up and down some stairs. Again, this is a temporary employee. So she complained the next day that her legs couldn't take the up and down stairs. So now they put her in an area where she has to sit or stand. She can sit or stand, but the area is very enclosed. And the next day she complains of claustrophobia. So now they're like, meanwhile, the supervisors are not involving human resources or any type of support. So the supervisor calls and says, we just need to end this employee. They're not going to be a fit. Well, imagine the company's shock and surprise a few weeks later when they got the EEOC and the PHRC notices for discrimination under the ADA. And the employer and the temporary agency were both on the hook. So here's what they didn't do. They didn't engage in what is known as the interactive process. I want you all to write that down. I do not have a slide on it. It's so important. We're going to talk about it for a few minutes, and I'm going to give you examples. So if a supervisor hears from an employee, I can't do that because of this, and whether they think it's a valid complaint or not, they should be referring them to human resources or the appointed designee for your organization. And the reason for that is what has to happen next, and this is written as part of the act. The employer must engage in what is known as the interactive process. Now, what does that look like? Well, that's having a conversation. Again, you meet the employee where they are, and we find out what's going on. And it can be like this. Help me understand why Bill says you can't perform your job today. Well, I'm having back issues. I'm sorry to hear that. How could we maybe help you? Is this a temporary thing or has it been ongoing? And you ask questions. You don't get so in the weeds that you could get in trouble with medical diagnoses, but you need to understand what's going on and why they can't perform their job. At that point, if you have a form, if you don't have a form, I'm going to suggest that you might want to get a form, and it's a request for accommodation form. Only after you engage in the interactive process. They fill the form out, it comes back to you, you review it, and then depending on what's on the form, you may be able to immediately come up with a way to make an accommodation. If you can't, you may need them to get more clarification from their medical provider, and that's okay. Or you may need to send them to like if you have an occupational health facility that you use, you could send them there for an evaluation. But when you do send that out, make sure that the physician is going to have a copy of their job description, because again, everything's tying back to those functions. Keep in mind, there is no federal or state requirement to have job descriptions. But I tell you, as a 35-year practitioner of human resources, I find them invaluable in not only ADA situations, but a ton of other things. So again, take a look. If it's been a while since you reviewed job descriptions, please consider giving them an update. All right. So making accommodations, what's reasonable? Well, what might be reasonable for a Fortune 500 company might not be as affordable for a small organization, a mom and pop retail store that has 15 or 16 employees. So it has to be reasonable and without what is known as undue hardship. Undue hardship is difficult to ascertain. There is no like dollar amount in the act that says if it's under $1,000, you must do it. But what it comes into is what if the company would take for example, a financial loss by providing this accommodation, then no, that might not be considered reasonable. But there are tons of resources out there. I'm going to talk to you about one in a minute. Again, maintain privacy of these individuals. Make sure that you maintain the respect, the privacy of them. If accommodations need made, and you're an HR person or a business owner, all you need to say to the supervisor is, Bill can't lift more than 50 pounds for the next 2 weeks, period. End of statement. You don't say, Bill's been diagnosed with a herniated disc, and you give them the bare facts and that's it. Again, tolerating poor performance unrelated to a disability is not an accommodation. Okay, if you have a performance issue, we've got to talk about the performance issue. And there's ways to have those tough conversations. Job Accommodation Network is one of my favorite resources for ADA accommodations. Their services are free, and they are so helpful and wonderful to talk with. If you call them and you have a situation where an employee is needing an accommodation, the JAN network can sometimes help you get that accommodation, or they think outside the box of things that you might not know about. An example, I had an applicant once who applied for a position, and we had visual acuity requirements, meaning you had to be able to see colors and your vision had to be to a certain level. This individual disclosed during the interview, when I reviewed the job description with him, he said, Pam, I can do the job, but I am colorblind. And I said, oh, well, gosh, well, so what I did is I went right at the interview. I went out and got a work sample, and I said, how would you do this then? Like if you're colorblind and you know that this red thing goes to the blue thing and you can't tell the difference, how would you do it? He knew how to do it. He already knew how to take care of his colorblind issue. There was some little chart thing that he could use, and he knew it. And so it was a no-brainer. We're going to hire him, and he's able to do everything. But Job Accommodation Network is a great resource. Just remember, when you're talking to employees, asking them generally how they are is fine. Asking if they can perform job functions is permitted, but asking them, if they can perform something that's not in the job function is not permitted. You can ask people about their current illegal use of drugs. You can say, you suspect somebody's under the influence, you follow your policy. But on more than one occasion in my career, I've called people in and said, hey, how are you doing? I have to be honest, your eyes are looking pretty dilated. Are you okay? Have you taken something? I find that being honest and very open with people and non-judgmental, you'll get answers every time. In addition to the Job Accommodation Network, please don't forget the Office of Vocational Rehabilitation. OVR is your friend. Many times they have great candidates that have disabilities that aren't even visible, that you won't even know that the employee has a disability. So as not only I'm plugging them as a recruiting resource and tool for you, but they are sometimes great referrals and information providers as well. So please don't hesitate to reach out to them. Again, their services are free, and they are great people to work with. So a real quick summary of the key points that I want to make sure you got today is everybody's covered under the act that is an applicant or an employee. A disability can be physical or mental. An alcoholic is a person that's covered, can be entitled to accommodation. A drug addict, if they're currently using illegal drugs, has no protection. A reasonable accommodation is any modification or adjustment to the job or work environment. And that includes schedule changes, by the way. If you have somebody, for example, that's a diabetic and they need to take more frequent breaks to check their levels, their sugar levels, and they may need to eat something more frequently than your other employees. Little schedule modifications and changes are considered reasonable accommodations. And the ADA is enforced by the EEOC. Many states do have other laws similar to the ADA that are also enforced at a local level. At this date in time, Pennsylvania does not. So here's a typical situation that I get. And if we were face-to-face in person, we'd be breaking into small groups and really doing some heavy lifting for the next few minutes. But for the past few months, you notice that Jim's performance has been a little off, and his quantity is about half of what it normally is, meaning his production's down. Jim has also made a lot of mistakes. That's not like him. When his supervisor questions his recent poor performance, Jim tells the supervisor that the medication he's taking for lupus makes him tired and unable to concentrate. So my question is, what would you do? And the backstory is Jim has been employed for 2 years and has always been an average performer up until recently. So I'm going to give you a minute or a beat to think about that. So what we've got here is we've got 2 issues. The employee is trying to tie that into one issue. So remember, you have a right as an employer to expect good performance, but now he's raised the flag. He now has a medical diagnosis that may qualify under the ADA. So you're going to take these into 2 separate chunks. You still have to address the performance, but you're going to talk to him about what kind of accommodation may help him. Help me help you is a phrase that I often use for employees. And that means getting him set up with HR or someone that can engage in that interactive process so we better understand how to help him. In this case, is it a shift change? If the medication's making him tired and he comes in at 6 a.m., maybe coming in at 8 a.m. would be better for him, to get a couple extra hours of sleep and put it on the back end of his shift. All sorts of ways to do things. Just you have to be creative. You have to be open-minded, and please, please, please document. One of my favorite sayings, and I've said it 100 times, is you love them all or hate them all the same. You cannot show different treatment to someone with a disability and someone without. Your job is to be fair, consistent, and treat everybody with dignity and respect. And so this case, there's 2 issues. One is the ADA and one is the performance that you would be dealing with. All right, we're going to go into the questions. Where can I find ADA requirements for e-commerce business selling products online? I actually do not know, but that is a question that somebody from OVR or the Job Accommodation Network could answer easily. I don't have that information. Drug abuse, we did answer that question. Here's a comment. I hear certain companies will not hire a person if they smoke cigarettes because of a higher insurance rate. Is that lawful? I'm a little bit struck. How would they know that somebody's smoking? I guess if you came into an interview and you smelled like smoke, they have a right to say that they're not, a non-smoking facility. They have a right to request that. They can charge people more for their insurance, smoker rates versus non-smoker rates. They can definitely do that. What if my company owns multiple businesses in several states, all have their own EIN? So in this case, if they all have their own EIN and they do different things, I would say that you're not covered. However, if they share the same benefit package, Shannon, then they would be, I would group them together. I personally would have to ask a labor attorney this question, but what I do know is I had a similar situation, and what it came down to is it was for FMLA, not ADA. We had a state in the South and a state in the Northwest that had, one had 75 employees, the other had 25. And the question was, are they covered under the FMLA? Well, the answer was no, because they were more than 75 miles apart. But there was enough other things that they did share in common, including they had the same EIN, they had the same benefit package, the same compensation scale, the same job titles, the same, so we ended up, we felt it was prudent to say, yeah, we're going to treat them all as one. We've had several applicants that failed our pre-employment physical and were not hired. They did not meet the physical requirements of the job. They are safety sensitive jobs, and for safety reasons, we do not try to accommodate. Are we exposing ourselves? So if they didn't meet, okay, to answer that in summary, it depends. So if they didn't pass the physical requirements, the question becomes, is there some way that with an accommodation, they could have met the physical requirements? So if the answer to that is yes, then yes, you should be, asking that question. One thing that I would suggest for you is to, when you interview people, you give them a copy of the job description and you say, this is the physical requirements and these are the essential job functions. Do you think you can perform these with or without disability, or with or without an accommodation? That may open up the dialogue in the conversation for them to say, well, I would need help with lifting, or I couldn't do any, bending. I can't bend over, I get vertigo or something. So I would definitely be showing the job description and asking that during the interview. If they're not meeting some other physical requirement, they're failing a drug test, absolutely no exposure there. If they didn't pass the drug test, you don't have to hire them. How should applicants' employees be treated if using marijuana legally for medical purposes? So this is one of those things, is it depends on what your policy says. If your policy says you absolutely cannot hire anybody that has medical marijuana, you don't consider it a alternative form of therapy, then you don't have to hire them. For safety sensitive positions, many employers will not be hiring people with medical marijuana. If it's somebody that's going to be sitting in an office, again, you have the same expectation as an employer. They can't come to work stoned. But we know that marijuana stays stored in the fat cells for a period of time, depending on the dosage and depending on how frequently they are smoking or ingesting. So what I would say there is, if it's a safety sensitive position, I would have my policy spell that out, that you will not make accommodations for medical marijuana. Let's see here. If an employee has displayed concerning physical issues that they are unable to perform the essential job duties, can we require them to stay home until we go through the interactive process out of concern for their safety? So my answer to that is you could, but to what end? How long will it take you to go through the interactive process? If I was going to choose that route, I would pay them to have them stay at home. I think if you could, you would find something light duty to do, or ask them, what would you feel comfortable doing? And if you could accommodate them in some way while you were working that out, that might be the best case scenario if they were comfortable with it. But again, it's all about meeting employees where they're at. And I would say to them, would you be able to do this? And, make sure that they're comfortable with it, until they have a chance to see their doctor or whatever you're waiting on. If the employee has FMLA, ADA accommodation, used all sick time, do we have them use vacation if they need time off? So that depends on what your policy says. So most FMLA policies are written that some companies make employees use part of their paid time off and vacation time before going to unpaid time. Some make them use all their time. Some don't make them use any time. Remember, FMLA can run concurrently with workers' compensation. And whether employees are getting short-term disability or not, it can all kind of be run together, but it depends on what your policy says. And if you don't have a policy that talks about leaves of absence, I urge you to get one written. Because again, if you let one person take a leave without using all their paid time, and the next person you say, I want you to use your vacation time, again, you've just created a situation where you're not leveling the playing field for everybody. You're creating some dissension and discrimination issues. Alcoholism is causing attendance issues. For sure, you call them in, you document the attendance, you lay out the expectations. How do you know that the alcoholism is the cause of the attendance issues, unless the employee tells you that? I would ask them candidly, and I would probably require a SAP assessment and ask them to follow the prescribed treatment. But again, it depends on what your policy says. If you have a policy that lays out what you should be doing, then please follow your policy. In the case with Jim, the scenario we just said, if the company does not address the issue with his medication, even after he told them, but instead kept pressuring him to perform better, what can Jim do? Well, what Jim could do is Jim could ask for an accommodation if he knew to do that, but it's not necessarily the employee's responsibility to ask for an accommodation. It's the employer's responsibility to understand their obligations under the Act and to make sure that if people need an accommodation, they know how to get one. So if Jim didn't know about the Act, then the employer should be advising him on, and working with him through that process. Is it legal to ask on the application if a person has a disability? No, I'm just going to say no, steer away from that. All you need to know is if they can perform the essential job functions with or without accommodation. You do not ask them during the interview if they have a disability. I'm not sure what take a test means.
I believe Regina was asking about how someone can ask about the disability. So I think the way that you answered the previous question that she asked is fine.
Okay.
Yeah.
Okay. How does ADA apply to customers? So again, at the beginning of my presentation, when I talked about in the beginning, we were thinking about, handicap accessibility. That's really, that's kind of the scope of it for customers. If there's something else for customers, I'm not aware of it, but keep in mind, I'm an HR geek, and that's really the scope of what I've done. So I'm really more employer versed than retail versed, I guess. If there is no way possible to make accommodations for the job, well, then you have to have a different kind of conversation. And frankly, that should be with a labor attorney. Or somebody that is very skilled in this area, because that would basically be, you're saying if there's no way to make accommodations and they can't perform the essential job functions, then basically you don't have a position for them. And if that's the case, then that would require a higher level discussion and a lot of documentation. I mean, you'd have to really be able to prove without a shadow of a doubt that they could not, there's nothing you can do to keep them gainfully employed. And that includes transferring them to another position. I mean, if you had openings and you were hiring for a lighter duty position and they couldn't do this one, you know, why wouldn't you consider transferring to another position? Oh, the temp agency. Yes. If an employee is working at a temp agency, does the employer need to make accommodations? Yes. Both the temp agency and the employer are held liable. And that goes back to the very first story I told about the temporary employee being on site and they kept shifting her around trying to find something she could do. Then they ended her assignment and she filed suit. She filed suit against both the temp agency and the employer. The reason for that is because she was under the employer's control. They supervised her. They gave her the work to do. So both the employer and temp agency were on the hook, and both of them had to defend that case. Wow, that was a lot of questions.
That was, but you did a great job, Pam. Thank you so much.
All right.
There's one more question coming in.
A test is required to see, if you spoke. Is there? Honestly, Regina, I'd have to take that myself to a labor attorney. I don't know. I've not heard of that before. I've heard it's very common now for employers to charge smokers more for their health insurance than non-smokers. But I honestly don't know about doing that in a pre-employment and not hiring someone because they smoke. I mean, because, for example, a good friend of mine was a smoker, and she started using a medication for smoking cessation. But during the first month of her doing this medicine, she was still smoking. So I don't really know how to answer that. That would be left for somebody that would be more comfortable answering it. So I'm sorry, I can't help you with that.
Okay. Well, thanks, Pam.
Thank you.
Yeah, thank you so much. This has been extremely valuable information, and I appreciate your time and your expertise with answering all the questions. There were a lot of questions, but they were great questions.
It's my pleasure, and thank you for asking me to present.
This is awesome. So, okay, well, we're going to wrap up today. I will be sending Pam's presentation, my presentation, as well as a recording to today's webinar. In addition, I will be sending a survey shortly after we sign off, asking you for your feedback on today's workshop. So it's awesome. It's incredibly important for us to get your feedback so that we know that what information you are looking for in workshops like this, but also in future workshops, so we can develop training that you are looking for. So be looking for that survey shortly. And then my follow-up email with the presentation will be in your inbox either later today or tomorrow. And if you have any questions, feel free to reach out to me. My contact information will be on my PowerPoint as well as my email communication to you. So, and with that, yes, go ahead.
Before we go, one thing, I forgot to do my disclaimer at the beginning. I am not a labor attorney. Anything that I presented today is based on my knowledge and my 35 years of practice in the HR field. It's not meant to be construed as legal advice. So if you need true legal advice, if you don't have a labor attorney, I got lots of them on speed dial for you. So just reach out.
Perfect. Thanks, Pam. All right. Thanks, everyone, and have a great day.
Thank you.
Thank you.